Good afternoon, everyone.
Good afternoon, Judge.
Mr. Starks.
I apologize for my appearances. I am on spring break, but I didn't want to miss this opportunity, so no disrespect to the court.
None taken.
And good afternoon, Judge Richardson. This is Attorney Parks, City of Atlanta. We're waiting for Stacey Miller to join. It seems that she did not get the calendar invite.
All right, we'll give her a couple more minutes.
How you doing, Your Honor? This is Sean Williams with the Cochran Firm. Pleasure. Thanks for giving us the chance.
Good afternoon. Good to see you.
Good afternoon, Your Honor. Stacey Miller, City of Atlanta.
Good afternoon, Ms. Miller.
Hi, I apologize. I never received the link to this hearing, so I didn't even know it was occurring. But okay, I'm ready to proceed.
All right. I think Mr. Starks requested this conference.
Yes.
And I've read the emails from both sides that y'all sent to Mr. Townsend. So, Mr. Starks, I'll let you go first and lay it out for me. Your
Yes. Yes, thank you, Judge. And I have tried not to burden the court with a lot of emails. The response that we gave was intended to be pretty concise as it relates to two issues. The more immediate issue relates to a recent deposition of an officer Ferreo, who was one of maybe 4 officers that were involved in a pursuit that ultimately led to my client, an innocent bystander, being struck by a vehicle and losing both of his legs. So that's just generally what the case is about. But primarily the witnesses in this case will all be police officers with a few exceptions. So the issue relating to Officer Ferreo is essentially this, Your Honor, and it's what I summarized in the email.
Let me ask you, I guess you don't have to repeat what you already wrote. When did you first, let me ask you this, when did you actually get Officer Ferreo served?
I can look that date up, but what I can tell the court is that we filed a proof of service on the docket in anticipation of maybe having this issue. We also sent over this morning the non-appearance transcript, which I think has that proof of service attached. So I could take a moment and look that up, but it was, and I'm only guessing, but it was certainly at least a week in advance of the actual deposition date.
All right. So did you have any communications with the City of Atlanta Law Department or about Mr. Ferreo's deposition?
Yes, I
before
did.
And after you served the subpoena?
Yes, before I served the subpoena, the communication we had with Ms. Miller is whether or not she could make this officer available, whether she would be representing him as a city employee. And the representations we got back from the city is that they could not make contact with this officer, and therefore she couldn't accept service of a subpoena for him, couldn't acknowledge whether she would be representing him, and therefore our response back to her was, so be it, we will serve this officer. And that is what we did, and that is why we did it. But for the city being unable to make contact with him not calling the city back, the city can't represent him without talking to him, we would have never taken on the burden of trying to serve an officer, which is not easy to do. So that was the conversation leading up to serving him ourselves with a subpoena, which meant finding him, going to whatever special unit he's involved in, check, subpoena, putting it in his hands. Then we filed the proof of service so that the city would know we have served this officer. We never heard anything back about Officer Ferreo objecting to the subpoena. We're still trying to reach him. Please give us another chance. We never heard anything, if I'm not mistaken, until the day before his scheduled deposition, when the city says, he's now made contact with us. We are now representing him, and he's not going to appear for a deposition in person, but we will make him available by Zoom. And so my position, again, lots of emails bear this out. We're not agreeable to taking his deposition by Zoom. We maintain our right to depose him in person. We've served him with a subpoena. He doesn't get the benefit of the lawyers working together, as we've certainly done and tried to do. He doesn't get that benefit, and certainly not the day before the deposition. And so that was made clear to Ms. Miller on the day before. And my suggestion to her at that point was, we will be there with the court reporter, as we were. We will document his non-appearance, as we did. And my suggestion to Ms. Miller was, you should either file a protective order or contact the court. And then the next morning, I think the morning of the deposition, Ms. Miller contacted your staff attorney. Your staff attorney got us on the phone. He heard from me essentially what I'm saying to you now, which is our position is that not only do we maintain the right to depose this witness in person pursuant to our subpoena, but we also want the expense for him failing to appear and for the court reporter appearing and making the transcript for us, for the effort that we had to undertake to serve him because he didn't cooperate and respond back to the law department. So that is issue number one, and essentially the main issue. The second issue, Your Honor, just relates to this ongoing problem with a number of different witnesses, specifically APD officers. And it's just, we've gotten very little done. So.
All right, so let's talk about the first issue. So really, let me just, from a practical standpoint, and it sounds like you've done depositions with city witnesses by Zoom before. So from a practical matter, you could have agreed to do it by Zoom, but you chose not to.
I guess I would disagree with that in part, Your Honor.
Okay.
From a practical matter, because of COVID, which we've all been dealing with, we've been taking depositions by Zoom. I guess the extent to which I would disagree with the court, assuming I'm understanding the inference, our preference is not to take depositions by Zoom, ever. We would never exercise that right. And in the years that you've known me, you've never known me to take remote depositions or conference. That is not our preference. That is not to our advantage. And frankly, I think the city and others have used the COVID era to create these Zoom depositions. It's very tedious. It's very cumbersome. It is not an effective way for plaintiffs to get information from a witness. So while we have done that by agreement, we have never said just unilaterally from here henceforth, we'll do depositions by Zoom. And the point I made to your staff attorney is that I've never seen an order from the mayor or from the city and there's certainly not one that I'm aware of from the Supreme Court saying that we're under some state of emergency where the parties are expected to take depositions virtually. So I guess that would be the only sort of qualification I would make to what the court has said.
All right, so,
Yeah.
I'll tell you that it's, your position is not unique among plaintiffs' counsel. They prefer to be in the same room and with the witness. They are generally reluctant to do depositions by Zoom. And I've dealt with a number of discovery motions where the fight is over whether the witness has to appear by Zoom. And generally my view on that is, we're in a very unique and difficult time. And generally, my view is if a party or a lawyer wants to would prefer to proceed by Zoom, given the current circumstance, I'm generally allowing it. That's not to say that I approve necessarily of the way this all went down. We're going to get to that, but I just say that for the edification of the parties is that, my general view is going to be if a party or lawyer wants to proceed by Zoom, at least until we've got some semblance of herd immunity or everybody's vaccinated, then I'm generally going to allow it. But somebody has to come to me before the date and time of the deposition to talk to me about that. So let me hear from you, Ms. Miller. Tell me about your attempts to get in touch with the officer in this case. Were you aware of this? You were aware of Mr. Stark's request? When did you start reaching out to Officer Ferreo, and what did those contacts look like?
Yes, Your Honor. I don't disagree with much of what Sam has said. Sam reached out to me first to get a number of officers scheduled for depositions. And I immediately reached out to those officers via email. And where I had a phone number, I reached out to them via phone as well, or to their supervisors if I didn't have a phone number for those officers. And I have that documented through emails and telephone conversations. However, of those officers, Farrow is how he pronounces. Farrow was one of the officers that did not respond to any type of communication, which I let Sam know I could not accept the subpoena on his behalf because I had not spoken to him and did not at that time represent him. It was not until the Friday before the depositions that were scheduled for that Monday that Farrow actually reached out to me. And he emailed me and said that he was trying to get in contact with me about a subpoena. My understanding is that he had previously reached out to the union, and then the union gave him my information for him to reach out to me. And so that's where he got my information. He just didn't see the emails, or I'm not sure exactly what occurred. However, once I was made aware of that, I spoke with him. I gave him a call back. We spoke. That's where the attorney-client relationship began. And then I reached out to Sam in the Cochran firm once they had confirmed the Zoom information, saying, hey, I do now represent Ferreo. And it was late on a Friday, maybe about 2 p.m. Around that time. And I said he will be present at the deposition in the same way that the city is present at the deposition via Zoom. There was never any pushback about the city being at the deposition via Zoom. We've done depositions in other cases via Zoom because of the COVID pandemic, and that was never an issue. In fact, we had a deposition scheduled for that same Monday at 1:30 via Zoom, where the city's witness and the city's attorneys were all being present. We're all going to be present via Zoom, and we're present. And that deposition went forward without any issue. And so from my perspective, it didn't seem that there was a real difference or a huge issue in that deposition moving forward. And in fact, on that Monday, we were present via Zoom, the city attorneys and Officer Farrow ready to move forward with the deposition. However, the Cochran firm and Sam or whomever he was working with never even got on the Zoom. And I sent an email to Sam saying, hey, we're here. We've been here for over 15 minutes. We would like to move forward. And that's where the discussion began back and forth about whether we should get the court involved. And that is what I did. And that's, what kind of snowballed into where we are here today.
All right, so a couple of questions. First, with regard to Officer Farrow, if that's how it's pronounced?
Yes.
So is is it your practice if you, now, Officer Farrow, he's still employed by the city of Atlanta, is that correct?
Yes, Your Honor.
All right, so if he didn't respond, what communications did you have with supervisors? Because certainly he should be directed to at least respond to a phone call, even if he chooses not to have, or you decide, the city decides that the city can't represent him. Certainly there's a way to get a response, and the way it appears to me, there was a good week plus time to get some kind of response from someone. So tell me what efforts were made other than a direct contact with the officer?
Yes, Your Honor. I'm not exactly sure what Officer Farrow did. I know that he said he spoke with a union rep. And so I'm not sure if the union rep told him that they would represent him or exactly what happened in that week. But he said that he.
Well, my question is different. I'm asking
Uh-huh.
what efforts you made up the chain to get some kind of response from him.
Right. So I would have to go back and check my emails to see exactly what email correspondence was made. But it's my understanding that it wasn't that he didn't reach out to anyone, that he did reach out to the union in order for them to represent them. So not me personally, but to someone else to represent him.
Your Honor,
I think this is Mr. Williams. Did you?
I apologize. I apologize. I just wanted to add something if Stacy was finished and if the court was finished. One of the issues, and I want to insert myself, is one of the issues we've been dealing with is with when we have other corporations we deal with, like Coca-Cola or somebody else we sue, they control the workers. And when we deal with the city, though, they control them when they want to, but then when it comes to these things like these depositions, we can't get in touch with them. We can't find them. You're going to have to do it on your own. And I sent a letter to Ms. Miller early in this case in an email saying, just so I understand the bar rules, because I don't want to be unethical, are you representing these non-party witnesses that work for the city? If you're not, I need to know, because then ethically I can go reach out to them or try to obtain their depositions or serve them with subpoenas. I never got a response for that. And when I finally did, they said they were not representing them. So we then took it upon ourselves, like every other case, to go serve these officers. It seems unfair to me, and this is the ultimate issue, that it's convenient for the city to represent these officers and control them on the front end, but then when they can't find them, they don't represent them. Then we do the hard work to get them subpoenaed, and then it changes up. And so that's my frustration on how all of this played out with this instance. Now we have a subpoena that should have been honored under the law, and now they want to dictate what happens.
So I hear you, Mr. Williams, and I understand your frustration. And we can go back more than 10 years from litigation that I had involving Mr. Starks, and those same frustrations were there back then. And I also understand it from being an assistant city attorney for the city of Atlanta, because I understand the frustrations in dealing with a bureaucratic infrastructure that is not always completely aligned. The police, the City of Atlanta Police Department is a client, but they are not always the most cooperative client. But if anybody is going to take a hit for that lack of cooperation, it's got to be the city and not the party that's seeking valid discovery. it's just not going to work going forward to say we can't reach them until the last minute when they reach out on their own. You know, going forward, there's got to be a larger effort up the chain on behalf of the city to get to establish some communication through the chain and make some determination before the eve of the deposition, before all the details are locked down and people are scheduled to appear, what's going on. I recognize there are circumstances in which the city has a conflict in representing the officer and in which they don't, and there are circumstances where the officer doesn't want to be represented, but that's got to happen sooner. And there's got to be some procedure established to where they are directed to respond one way or the other to legal counsel. Otherwise, the only fair thing for me to do is sanction somebody. Now, maybe in the future, it's the officer that has to be sanctioned for refusing to respond, or maybe it has to be the city. You know, I don't think sanctions are appropriate at this juncture, but I think we need to have an understanding that the city has got to show a better effort up the chain for establishing communication with these officers, and whoever up the chain needs to know that they need to make sure their officers make themselves available at least by email to say yes or no, so that counsel can inform opposing counsel what's going on in a timely manner. So I just want to make sure that's understood going forward, because I do think that it is, while I recognize the difficult position that city's council is in, I think it's unfair and an undue burden on opposing counsel to have to navigate this, to have to serve, to have to serve, and then find out on the eve of the deposition, well, oh no, they're not coming, even though we had to go through the effort of getting a process server to find them and serve them. Now they're not coming on the terms that were set by opposing counsel. Now suddenly we're opposing different terms, you know, based on there being counsel. I don't think it's a fair way to proceed, and I understand the frustration. So let's talk about what we're going to do about this particular deposition. I'm going to allow the deposition to proceed by Zoom. But the next time we get this last minute, I'm not going to let it go again. It was a valid subpoena. No motion for protective order was sought. I don't think there are valid grounds for a motion for protective order. We just can't have that again. This one will go forward by Zoom. You got one pass, one free pass, but only one on this one. So let's talk about what we're going to do going forward.
Your Honor, if I could say this, we, the city of Atlanta, a lot, and this is a problem that we're having, not just in this case, but we we have it because we deal with the city of Atlanta a lot. And so, and that's part of the reason why what we're requesting is cost for the undertaking that we were forced to make based on the city saying we can't make this guy available. And I don't want to send a lot of emails to the court, but I told Ms. Miller from the very beginning, we were not agreeing to a Zoom deposition. We would have the court reporter available because I anticipated this. And so what I really think would help, Your Honor, is for the court. Frankly, I wish this were transcribed so that we would have the benefit of at least having a record of this experience with this court and what Your Honor said, because Judge, without you issuing an order pertaining to this case for what your expectations are, the ground rules for the lawyers, the court may not be able to bind the city employees or bind APD, but I guarantee you an order that's directed to council and to the City of Atlanta Law Department that says what this court is saying in essence in this conversation, I believe that that is something that would help. Short of that, Your Honor, I think we'll be right back here again, because everything else that we might talk about, it just relates to the same issue. We still, and without the court getting down into the weeds of what about this witness? What about that witness? We would like for the court to send some sort of order to the city, essentially saying the extent to which individuals have been identified that are current employees, whether in police reports or other documents, does the city represent them or does the city not represent them? So that we don't have to ask every time we want to depose a witness. Right? If the city does not represent them and council has to subpoena them, then we have the right to do that. And frankly, again, unless the court's saying we can't ever, at least for right now, take a deposition in person, if we got to go and serve you, I feel like we can't. It's kind of hard to notice something by Zoom when the lawyer on the other side is not really in on what you're doing. So the reason we notice them in person, just practically, is so that you can come to our office, so that if there's any confusion about whether the lawyer on the other side agreed or didn't agree, we know where the deposition is noticed for. So we're waiting for you. We're not waiting for Stacy to see if she's going to get on. We're waiting for you at our office because that's what your subpoena says. And so,
all right. So let me address the first point, and then I'll address the second. The first point, in terms of there being a record, right now this proceeding is live on YouTube. And if you go back to my YouTube channel, this video is going to be here. So you're free to transcribe it. You're free to reuse it if you need to reuse it. But I think I've made my instructions clear. And in case it's not clear, let me say this. If the city says it cannot commit to representing a police officer client, and you have to serve a subpoena, once the police officer client is served, they're bound by the method of appearance you designate. In other words, so if you designate in person, they have to be there in person. If they want an attorney can participate in person or by Zoom, but they will have to be there in person.
very well, that is understood, Your Honor.
And
Yes, Your Honor.
so
And
that,
if I,
and so, you know, Ms. Miller, you're going to have to make that clear to these folks up the chain, is that they're not going to get any last minute, oh, oh, I just held this in my pocket and didn't respond to anybody, but now that it's happening tomorrow, now I want a lawyer, and now I don't want to have to go over there. It's going to be too late.
Yes, sir. And if I may respond to Sam, what he said previously, with all due respect, we have had many depositions together where we've had officers that were non-parties. We've had a case where over 30 depositions were scheduled. And that was something that the city took on for non-party witnesses to make sure that everything was scheduled and everything was in order. So to now say that, oh, we're having a severe issue with the city, I don't believe that that is a genuine issue. We have one-off occurrences where we are trying to locate different officers that are non-parties that have maybe switched zones, that have maybe switched teams, and that we are doing the best that we can and above and beyond what we can do and what we should do maybe in some of these instances. And so I want to make that clear for the record that I do not believe that this is a severe issue. When cases come and we have multiple non-party officers, we are doing the best that we can to make sure that they are there and they are represented. However, we cannot determine beforehand whether we represent someone that we've never spoken to. And even with our professional rules of responsibility, there are certain officers that we can represent because they are higher up in the command of our municipal corporation. However, the officers that are lower down, it's not an automatic that we represent them. They can be represented by their own attorneys. They can be represented by union attorneys, and maybe even a different attorney if there's a conflict. So that is not an automatic. And I'm sure Sam and Sean appreciate that. And I just want to make that clear since we are on the record.
Right. So I'm not suggesting one way or the other that there is a serious problem. As I mentioned before, I recognize the difficulties that y'all have in-house and representing the multiple clients that you represent. I'm trying to balance the burdens and the expenses as best as I can under the circumstances. And what I'm saying to the city is the line of communication has to be established earlier. And if the Cochran firm comes to you and says, here are this list of 5 current police officers who we want to depose, you should give you a reasonable amount of time to come back and try and establish contact. But if they won't respond, either up the chain, and you go up the chain and they're still not getting any cooperation, and the Cochran firm has to go through the expense of subpoenaing them, I suddenly got religion is just not going to work as conveniently for them, because there is an expense that comes with that difficulty. And I need to balance it somehow. And I think the only way I can balance it is in favor of the party that has a validly issued and served subpoena. I mean, I've got to follow the legal process on that. And I'm trying to give y'all a reasonable opportunity to get to the clients. But if the clients are being uncooperative, then the side if city witnesses are being uncooperative, the inconvenience is going to have to fall on the city. That's the only fair way I can balance it. Now, I don't take any issue with anything you have done as an attorney. But if you have reticent or slow-moving clients, it's going to work against y'all.
So, Your Honor, I guess I really, in reference to the other issues, which all relate to what we're talking about now, as I'm sure the court knows, we have a right and the need as the plaintiffs to be able to take depositions in a certain order, which we've made clear to the city on a number of occasions. Here are 4 witnesses or 5 witnesses we want to depose. We'd like to depose these 2 before those 2. This is the order we'd like to have. Now, this compounds the problem of not knowing who we're going to get at any particular time. And so we could certainly go through and talk about the back and forth of all of that. I guess all I want to say to the court is that we have a right and an expectation to be able to take, absent some sort of extenuating circumstances, somebody in the hospital, we have the right to take witnesses' depositions in the order that we want. That is a problem that we have. Now, I don't know whether that problem is because of the other problem and they can't reach certain people, so we can never get the order we want, but I just want to make the court aware of that. I could give examples, but I don't know where it gets us. The bottom line is that we've been having an issue scheduling depositions. And let me say this, I don't think this is Stacy playing games with us, but these APD, they're not above the law. And they got an SOP that talks about subpoenas for court. And I still believe, Your Honor, if there was an order from you to the chief or that the chief of police was copied on, if the chief knew that their officers were not responding to subpoenas in civil cases, I'll bet you it would stop. It would stop.
Well, Mr. Starks, we may get there.
And that doesn't put the burden on Stacy, who but I'll bet you it would stop.
We may get there, but I'm going to give her an opportunity to warn them that an order and sanctions may be coming if the lines of communication don't open up. I'm not going to, it's going to depend on the circumstances of that particular issue. This is the first time that I've dealt with this particular type of issue. I understand the issue, and I just want everybody to understand what my ground rules are going forward before we start doing something that looks punitive. I don't want to do that, and I don't know that there's any reason to do that at this point. It's going to be frustrating. It's going to be difficult to schedule. Mr. Starks, you are entitled to get them in the order you want them, and if that means being flexible on scheduling deadlines, the court will be flexible on scheduling deadlines. Okay. But at the same time, we don't want undue delays either because of prolonged scheduling issues. I don't know that we're at that point yet, but I hope with this guidance that going forward, y'all be able to move forward with a full understanding of how it's going to go the next time, if there is a next time we have to come back on the same issue or a similar issue.
Well, I understand, Your Honor. I guess unless Mr. Williams has more to say, and unless the court wants to get down into the weeds of some of these other individual depositions that we're still going back and forth about, my feeling is that based on what the court has just said, and again, I don't have any issues with Stacy from the standpoint of, I don't believe that any of this is coming from her, but it's coming from these officers. And I think they're doing it on purpose. They're gaming the system. The day before, the Friday before is when you go and call the lawyer back who's been trying to reach you. So I guess I am, other than, again, we still maintain our request for costs, which are nominal. But unless Mr. Williams has something else to say, I feel like the court's pronouncements should be sufficient guidance. Stacy and I have worked together before, and it should be sufficient guidance to get us to where we need to be. If not, I guess we'll be right back with another phone call.
You know how to reach us.
Your Honor, can I add one thing? I think the approach of the court is the best way to move forward on this. I know we requested fees and costs. I will waive that or remove that part of the motion. We just really ultimately wanted the court's attention and the city's attention so we could be efficient and productive, because I frankly have a client who paralyzed now, who wants an opportunity to get this thing to a court and to a jury. And that's what the real frustration has been, because he literally, his life has been changed totally. And these delays don't get him closer to the courtroom, including the pandemic. So that's really what we were trying to do. So to the extent on the record, I need to remove any request for sanction or fees, I will do it formally now.
All right, very good. Thank you, Mr. Williams. I think we can leave it there for now. I'll say if you need to do a revised scheduling order, I'm receptive to it. I don't see that it has been revised. I think your close of discovery is currently set for sometime in May. But I think naming experts is either on the horizon or is just recently passed. So if we need to get that locked down, let's get it locked down, and just keep me apprised if we have any more issues with moving forward.
I think we're going to definitely need a revision of the scheduling order. We will get with Attorney Miller and try to work something to get before the court, but we're definitely going to need one because of the issues we've had on scheduling these depositions.
All right, very good. Thank you all.
Thank you, Judge.
All right.
Thank you, Judge.
Thank you, Your Honor.
Have a great afternoon.